Good evening, good afternoon, everybody. I'd just like to welcome you to this webinar and thank you for joining us. I'm here with Adrian Berry, now KC, as you'll see from his name label, and also with Ava Dorr, who's going to be joining us in a moment to deal with the remedies section when we come to the end of this session. Thank you. What we're covering today, as you know, is the insight into the recent changes to the good character requirement in the Home Office naturalisation policy, with effect from the 10th of February 2025, with a focus on the dangerous journeys exclusion. So rather than telling you what we're going to talk about, I think I'll just hand over to Adrian, who's going to start by talking about where the context in which this is operating. So thank you very much, Adrian.
Thank you. Today we're going to cover a number of topics in the time allocated to us. We're going to look at changes, obviously, which have been introduced from the 10th of February. We're going to look at the scope of the way in which the term dangerous journey is used in order to assess whether a person is of good character now. And we're going to look at the key topic really for today, which is how to make effective representations to avoid a refusal of citizenship. And we're going to go through all of the factual and legal matters that you might want to raise in order to, or perhaps which you should raise, in order to head off the idea that a person can be refused British citizenship under the good character requirement because they have made a so-called dangerous journey. We're also going to look at the implications specifically for specific groups, for refugees and for children. The underpinning of all of this, which is the introduction of crimes of arrival in the criminal law, introduced by the Nationality and Borders Act, and then extended bit by bit, including there are some potential extensions further in terms of the criminalisation of arrival in UK territorial waters under the Border Security Bill, which is currently before Parliament. We're then going to look at some equal treatment considerations, both really under the Equality Act and also under the Human Rights Convention. And then at the end, Ava's going to look at legal challenges and also administrative remedies as well. So it's quite a lot to pack in. And so the jumping off point, which I'm sure we're all very familiar with, but it's worth recalling, is that there are three statutory bases for where the good character test intrudes. The first is in relation to naturalisation, and that can be both under section 6.1 and under section 6.2, and there's a mandatory, if you like, if you can put it in those terms, good character test there. And you can see that on the slide. And so that's for all adults who are applying to naturalise. And then if we have the next slide, please, Anisha. The second one applies to a whole range of applications for registration for registration as a British citizen. And the key thing to bear in mind in all of this is that not all applications for registration, and registration is, of course, usually the fast track or more facilitated way in which we can apply for British citizenship as compared to naturalisation. That many of these provisions have a good character test imposed. And of course, here it applies to both young people children effectively, who've attained the age of 10 at the time the application is made, as well as to adults. Of course, naturalisation is only for adults. And so you can see there on the slide a range of categories at section 41 subsection 1 of registration categories where the good character test applies, and it's not everything. It's not in relation to cases, generally speaking, of historic sex discrimination, or where a person was born so-called illegitimate or out of wedlock, but it does have a whole range of issues, most commonly section 3.1 in relation to minors, sections 3.2 and 3.5, registration of minors by entitlement. And so you can see there that there is an extension of that requirement there. So of course, somebody coming to the UK on a dangerous journey, in principle, as a child and as a minor who applies for British citizenship, in principle, this test can be applied to them. And then if we have the next slide, please, Anisha, you'll see that in addition to that, don't forget the provision made for adults to register in special circumstances, the new section 4L introduced by the Nationality and Borders Act 2022, which obviously deals with cases of historical legislative unfairness, and then also the act or omission of a public authority, and also other exceptional circumstances where an adult, if they can fill one of those particular criteria, or one or more of them, in fact, can go on to make an application at discretion to say that they ought to be registered as a British citizen. And you see here there's a slightly different formulation that in this test, and whether that amounts to very much is a moot point, but it's worth noting. The Secretary of State may take into account whether the person is of good character, whereas in the previous formulations, the test really is whether or not the Secretary of State is satisfied that the person is of good character. And the interesting thing about this particular provision is may take into account, not must. So here there is a discretion for the Secretary of State to decide not to apply the good character test. And in the guidance accompanying Home Office guidance that comes with Section 4L, what you find about registration in special circumstances is that it's the policy of the Secretary of State to apply this in circumstances, to waive the good character test in circumstances where a person would have otherwise automatically acquired British citizenship in the past, but for historical legislative unfairness. But if a person was shut out from applying for British citizenship in the past by historical legislative unfairness, she will apply the good character test. So there's a policy decision as to how this discretion, whether or not to apply the good character test, is used in respect of Section 4L. But it remains the case that under the statute, it's possible to argue in exceptional circumstances that even where a person was shut out from making an application at discretion in the past, that they should be it's possible to invite the Secretary of State to disapply the good character test. So if we can have a look at the next slide, please, as well. So I'm not sure. I think this is maybe my final slide at this section, but it's the Secretary of State has to decide or must be satisfied in the statutory position that of the statutory position of whether or not a person is of good character. It's not like other provisions of say, for example, for naturalization, whereas there's discretion to disregard a requirement. You cannot disregard for naturalization and for all the registration categories other than Section 4L. You can't disregard the good character test. You have to satisfy it. And so it's an evaluative exercise. And the question is, at the date of decision, are you of good character? And so that's the sort of the jumping off point. There are a number of times people say, well, it shouldn't apply to me because these things have happened to me, and therefore I ought to get the benefit of the good character test. That won't be sufficient. You do actually have to be of good character. It's the Secretary of State who decides in the first instance, and the case law establishes that she's entitled to set a demanding standard. And that's why we're focusing today on making representations, because the more detailed and the more particularized your representations are, then the better it will be for your application, the harder it will be for the Secretary of State to say no, and to say no giving reasons as to why she doesn't accept the representations. So today's focus is going to be really very heavily on what you say about the new, how you try and satisfy the test that although it's the case that that there is a policy in relation to dangerous journeys, it's not mandatory, and it's only that the Secretary of State will normally apply that policy to exclude someone from citizenship because for want of good character. The good news is there's no definition of good character in the legislation, despite the very lengthy policy which exists. And so there are always, even as the policy itself recognises, exceptional circumstances in which you can make representations that, notwithstanding the content of the policy, there are good reasons as to why you should be judged of good character now at the date of decision. And then the focus is always, of course, on the date of decision. And the significance of that for today's purposes is that a lot of these dangerous journeys, they might have been made at any point in the past. They can be of some considerable vintage. The only, as we'll see, the only criterion for the application of the policy is that you apply for citizenship from the 10th of February this year. So, of course, don't forget that when we're looking at this, that essentially the doctrine of redemption applies, that you might have done something in the past that the Secretary of State considers adverse to satisfaction of the good character test. But all the things that you've done between then down to the date of the decision as to whether or not you should be considered of good character are also in the pot. So it's very important not to focus only on this one particular provision in the good character policy, or this one particular incident in a person's life, but to remember that you can throw other things in because it's evaluative, because it's cumulative, because it's concentrating at the moment of who you are and by reputation effectively at the date of decision. As we'll come on to see, there's an awful lot by reasons of fact, matters of fact, and also legal propositions, which can bear on this question of whether you should be judged to be of good character now. And so when we look at this dangerous journeys policy, we need to always to bear that in mind, that the overall holistic approach remains the overarching constraint on the Secretary of State saying no. So I think I'm going to stop at that point, hand over to Sonali, who's going to pick up on the content of the new test. Thank you.
Thanks very much, Adrian, and I'll come back to you when I've come to look at the criminal provisions. So this is the new version 6 of the nationality guidance that has caused quite a lot of consternation amongst those advising in this area. And I think we just need to understand clearly what it says and what it doesn't say, and also potentially what challenges there might be to it in any event. So, as Adrian has identified, of course, that the character requirement is not set out in statute, and the approach within the policy itself confirms that the 81 Act doesn't define good character, but this guidance sets out the types of conduct which must be taken into account when assessing whether a person has satisfied the requirement to be of good character. And again, as consideration must be given to all aspects of a person's character, including both negative and positive, so criminality, immigration law breaches, and deception, as well as positive things such as contribution that a person's made to society. So again, it's an evaluative provision, as Adrian has set out, and I think that's a really important consideration, rather than thinking as a blanket that there's going to be an exclusion. That's going to be maybe part of a litigation challenge as to what the ambit of the policy is and the lawfulness of it is, by which we'll come on to look at in a moment. So again, this is straight from the guidance, but important that we recognise it. The list of factors is not exhaustive. Each application must be considered very carefully on an individual basis based on its own merits. So again, there's a whole range of factual considerations that need to be put to the Secretary of State in any application and then in any consideration and any lawful decision making, and then potentially, if a court were coming to look at whether they were lawful, those considerations were considered lawfully, you have to front load it in your actual representations in order to get a decision that may reflect proper consideration, or at least purport to reflect proper consideration of those. So that the policy states you must be, the decision maker must be satisfied the applicant is of good character. And to facilitate this, applicants must answer all questions asked of them during the process honestly and in full. So we've seen a lot of that in the deprivation cases on fraud grounds and so on, as to what was said at the time of application. But the focus of this policy and the policy change relates to the method of arrival. But in this context, it's important that persons are informed the Home Office of any significant event or change, or any mitigating factors that could have a bearing on the good character assessment. So that's just the guidance as it's set out in the relevant part. Can we go to the next slide, please? And this is the key change that we're all being rather exercised about, which is that arriving without a change that's arriving without a required valid entry clearance or electronic travel authorization, or having made a dangerous journey. Now, the first important thing to recognize is that what was in the guidance in any event was reference to overstaying and illegal entry. So there was already a reference to overstaying and other immigration breaches, and how those may or may not be disregarded depending on passage of time and other factors, and that you'll see that was in the extant guidance before the 11th of February. The critical thing that has changed is that from a person who applies from this new date, the 10th of February, who's previously arrived, will normally be refused, and for those reasons that we've just set out there. And the dangerous journey is said to include, but not limited to, traveling by small boat or concealed in a vehicle or other conveyance. It doesn't, for example, include arrival as a passenger with a commercial airline. So again, that's on the face of the policy, bearing in mind that it did previously, in any event, refer to other immigration offences, including overstaying. Next slide, please. So as set out here, just to reiterate, so this is again answering some questions people may have. It applies to everyone who applies for a grant of citizenship from that date, so not applications that were already in the process. And the material scope is that they must have arrived without a valid entry clearance or ETA and having made a dangerous journey. Next slide, please. The definition of dangerous journey is non-statutory and non-exhaustive. So that's it includes, but is not limited to, traveling by small boat or concealed in a vehicle or other conveyance. Let's assume crossing the English Channel in a small boat, concealed in a car or lorry, or potentially even in an aircraft. And it doesn't include arrival as a passenger with a commercial airline, as we've said. Next slide, please. So, and again, as Adrian has emphasised, those who fall within the personal scope of the guidance and the material scope of the guidance will normally be refused citizenship. And so back to the real focus for where we are now, which is because people are contacting us saying, well, should or should we not apply? We don't really know whether we should invest the time and the money, in particular the money, in making this application. We don't want to be refused, and we also want to know what we should do, because if we are refused and we have no access to our original national origin citizenship, particularly if we're a refugee. So in applying for citizenship, it's critical to make representations as to why the presumption, which is what it is in the policy, it's a presumption, a should normally or will normally, ought not to apply. And there's scope to avoid its application for reasons I've just come on to now. Can we go to the next slide, please? So first of all, it's good character holistically that matters at the date of the decision, as Adrian has emphasised. You can emphasise whether or not you've in fact met or addressed the dangerous journey criteria on its facts, and make submissions as to whether or not your situation ought not to be treated as a dangerous journey for legal reasons. So we've had queries about people coming in, for example, via Ireland or Northern Ireland, which was an illegal entry, but without a valid entry clearance, but not a dangerous journey, for example. And there is, again, a lot of confusion and misapprehension about which side of the line that may fall into. And again, importantly, in any representations, addressing factually and legally why the will normally presumption ought to be disapplied, as well as addressing any other factors that go to good character at the date of the decision, which is obviously a prospective question. Next slide, please. And I think yes, but just in summary, we've talked about what is not a dangerous journey on the facts, not a small boat or other relevant conveyance, not concealed or not dangerous on any other basis. It's important to break down each element of the policy that may be said to be held against you, and address that in the context of how you point to character and good character, and why when you come to a holistic decision on the question of character, that it shouldn't be applied adversely to the applicant. Next slide, please. Critically, and this is perhaps the focus of what we want to say today, that the representations for certain classes of people in particular, we say there should be representations as to why that a person shouldn't be deemed to be not of good character because of a dangerous journey that they've undertaken. So, for example, and I think we've seen some clarification on this, which we'll come to in a moment, from Baroness Lister, an answer to a PQ to Baroness Lister, but somebody who's arrived as a child. So did they have agency in the decision that they took when they arrived as a child? You know, were they deemed to be responsible for their actions? And that so the policy provision has to be read compatibly with Section 55 of the Borders and Citizenship and Immigration Act duty. It's not a power, it's a duty to have regard to the best interests of children and the UNCRC, as well as Article 8 ECHR. So first of all, the class of, again, I've had a lot of queries from people representing refugee children in particular, but it isn't confined to refugee children, to address the question of agency and culpability. The second cohort are those who have been forcibly displaced and had fled to seek protection. Now, this is a really critical aspect of any representations that can and should be made, in my view, if you are somebody who's been recognised under the Refugee Convention, and or somebody potentially who's got humanitarian protection. The Refugee Convention has under Article 31 has a non-penalisation clause. And so that is for refugees, for persons who shouldn't be penalised because of their method of arrival. They didn't come directly to the UK in this context in order to seek international protection. That's a critical. We've been litigating Article 31 most recently in the context of criminal prosecutions for small boat arrivals, the crime as it now is of illegal arrival or attempted illegal arrival, and whether that's compatible with Article 31. And the current thinking from the Court of Appeal in the criminal context was, well, it doesn't afford somebody a defense, but it is relevant to the discretion that the CPS have of whether they should be prosecuted in the first place. So similarly, Article 31 is obviously relevant, directly relevant to the question of whether a refugee, should have the dangerous journeys criteria applied to them, and negatively applied to them in the context of a good character decision on a naturalization application. So there's a clear framework. There's no reference, as far as I can see, in the policy on the face of it to Article 31, although there is reference to looking at another link for additional considerations for refugees. But again, I think, as I understand it, there's a policy challenge to this policy, which directly refers to the Refugee Convention and the compatibility of this good character policy with international law and Article 31 and Article 34 in particular, but not limited to those. Article 34 of the Refugee Convention, again, is an obligation on state parties to facilitate assimilation and naturalization of refugees. And that, again, for persons who are going to be who've been granted refugee status, obviously granted indefinite leave to remain, because that's a criteria that's necessary criteria for naturalization in any event. Those people are not having cessation clauses applied to them. So once you get to that stage of your refugee journey, in that you've acquired status as a refugee, you've acquired settlement, and the next step for you is to look to naturalize, then Article 34 of the Refugee Convention makes express provision for states to facilitate that and not penalize applicants by reference to their method of arrival. Now, any representation must clearly address that, and in the same way that we were in the context of the criminal prosecutions cases, that the CPS guidance in the context of criminal prosecutions cases directly engages with Article 31, and that's the kind of provision we'd expect to see in a lawful policy. And it's certainly, in any event, whether it's in the policy or not, it's certainly the kind of representations that need to be made to the decision maker in a naturalization case. And of course, you've also got the non-discrimination provisions under the Refugee Convention as well. Those are all the framework articles for making those representations. The fourth category of persons, I'm taking this quite quickly, but this is just really a sort of roadmap, if you like, for how to structure representations. The fourth category of person is the persons who fall within under the State Persons Convention, and again the Article 3 non-provisions there, and the Article 32 obligation to facilitate and assimilate those who and naturalization of stateless persons. So these are the kind of cohorts for whom the policy does not to whom the policy does not speak, but to whom legal representatives need to be aware of how to put forward those arguments. And I'm afraid one of our that we come to today is that almost everybody who's making an application who might fall within this guidance absolutely needs to have legal advice and representation in order to make an application, not least because of the financial and time investment, but also to make sure that they get a lawful decision. Can we go to the next slide, please? So again, why other arguments and representations as to why they ought not to be treated as having made a dangerous journey for legal reasons include, of course, importantly, for people who've got a claim or an account of trafficking, and which has led them to the UK or been brought to the UK. That's again absent as far as we can see on the face of the policy, and that's why it's important that those criteria and that history is addressed in any application. So by the time a person comes to you, they may have had a trafficking account accepted, they may have had a conclusive grounds decision, they may have a refugee status decision, they then have ILR, and looking forwards in the application for naturalization does involve combing back through that kind of history and looking at implementing or addressing the implementation of the legal obligations under the international agreements in relation to trafficking that we've set out there. Secondly, and I think again really importantly, that we need to be looking at ECHR rights. So there's a traditional sort of view that citizenship doesn't ordinarily engage Article 8, but the Strasbourg Court has looked at that question rather differently over time, particularly where there's a discriminatory denial of citizenship or an arbitrary denial of citizenship. And we've seen arbitrary denial in the case of Usmanov, and we've seen discriminatory denial in the Genovese Malta case. So there are legal handles on which we can pin representations in relation to why it may be a breach of Article 8 to deny a class of person by reference to their method of arrival citizenship by way of naturalization. These are very fact-specific and law-specific, legal context-specific arguments, but it's not by any means to suggest that because this policy is in place, that swathes of people will be shut out or must be shut out. And making representations and inviting a decision which can then be scrutinized by the court is a really important stage in the process. And again, also recognizing the interpretation and application of other ECHR rights in accordance with other human rights instruments in relation to children, women, persons with disabilities, and so on. All of those factors may play out in the representations that can address why a person ought not to be treated as excluded from or deemed to be of good character as a holistic assessment simply by reason of having made or undertaken what could be categorized or has been, in the view of the Secretary of State, categorized as a dangerous journey. And that, Adrian, you may have things to add on that if you wish, when we come to the more discursive parts of our presentation. And the final issue there again is compliance with the Equality Act obligations. Can we just go to the next slide, please, on that? So, sorry, I thought we were going to come to the slide on Equality Act. Doesn't matter. I'll deal with that in a moment. the representations, as I say, need to address the will normally presumption that needs to be disapplied. Other factors that establish good character for the date of decision, those other matters which will be at large. The Secretary of State has a broad evaluative judgment to make, and in order to, when you're making those representations, we need to say what is good, as in what is positive and what is properly a matter of character, and for the applicant what needs to be said. So again, method of arrival isn't ordinarily necessarily a question of character. It is a context specific, often single act, particularly in the refugee excuse me, and trafficking and child context. So just let's recall that. Just going on to the next slide. This was an important update that just came through from the PRCBC patron, Baroness Lister. And I think hopefully some people will have seen it, but for your, importantly, for your records and information, this is the written answer received by Baroness Lister to her question on the current policy changes. So are they consistent? The question was whether the good character requirement guidance is consistent with the practice of disregarding immigration breaches outside a child's control. And the answer, as you can see, isn't quite as sort of unequivocal as we might hoped. When assessing good character, it is normally appropriate to disregard immigration breaches if it's accepted that this was outside the applicant's control. Given that illegal entry is normally considered outside a child's control, most children would not be held accountable for their immigration breach. And the new amendments to the good character policy didn't alter this position. Well, that's not clear on the face of the policy, first of all. Secondly, it still clearly retains a situation where it would be held accountable and where that wouldn't be disregarded. So there certainly may well be more representations to make in the context of any children that are being represented. And I know I had some queries from Refugee Council on that. But importantly, and I think it's also really important for anybody who's here from a local authority, I haven't checked the list, but those who are dealing with children in care and or children who've left care, former looked after children, I think it is very important to scrutinise very carefully what the alleged conduct is, what the policy says, and what the PQ has responded to. It's going to be quite a careful consideration, particularly for those representing children or who stand in place of parents for children. Can we take the next slide, please? Actually, Adrian, did you want to talk about these crimes of arrival?
Yeah, no, sure, absolutely. This all fits together in the context of an overarching government policy, which is to effectively, for what in practical terms, introduce a range of barriers to people arriving in the territory where they would be subject to the jurisdiction of the UK for the purposes of claiming refugee status and for claiming protection. And the criminalization of people crossing the channel, irrespective of their journeys, is really to brand them and to treat them as well, to create them as criminals in a sense. You create crimes of arrival in through the Nationality and Borders Act of 2022. Then you brand the people as criminal arrivals, which wasn't something which could be done beforehand. And then the policy on making dangerous journeys across the channel being seen as a mark of bad character or of being not of good character, so that you will normally be refused, completes the process of segregation of people from those who would otherwise be on a route to a grant of leave to remain, settlement, and eventually citizenship. And so you have to see the two things in harness. What they're designed to do is to prevent, in a sense, prevent integration, because not only is there criminal behavior and the person becomes criminalized, but also they can't take that final step years later to becoming a British citizen. They stop always as a kind of permanent resident, a sort of denizen who is prevented from taking that final step. And essentially, what's happening is the manufacture of what will happen if this is adhered to is the manufacture of a large permanent residence population who are not allowed to become British citizens, which runs directly counter to what we normally have as an integration agenda. So what you see here on the slides are firstly principal criminal offences which dovetail with the policy, and often may well be a person concerned may, in terms of if they're subject to this offence by virtue of being a recent arrival following this implementation of these offences under the Nationality and Borders Act of 2022, they may well have committed one or more of these offences, arriving without valid entry clearance knowingly and being convicted of committing an offence. And if we turn to the next slide, you'll see that obviously I think the alignment's gone slightly. They're all supposed to be in one left-hand justified column, but you see that there is a range of collateral offences connected to that as well, where you have to be very, very careful. Of course, the new policy in respect of crimes of arrival in the good character test is also takes its place alongside the suite of will normally refuse for a period of time provisions in the good character test, whereby people who are illegal entrants or overstayers were subject to 10-year plus cooling off periods. And so the innovation here is for those applying from the 10th of February is to adjust the policy and the good character test in respect of people arriving unlawfully, to say that if you come from this point onwards and you've made a dangerous journey, you're subject to this new crimes of arrival will normally exclude, which doesn't have a 10-year marker after which your application for naturalization or registration, as the case may be, will be considered on the merits. And so that's an important point to bear in mind. And if we have the next slide, please, Anisha. So we come on to look at the Equality Act, and I think one of the things we just want to emphasise today is that in making your representations, and as we'll come on to see, and it's important not just for getting an application over the line, for getting it granted, but also for if Plan B, to always have one eye on Plan B if you might need a legal remedy afterwards, is that you want to bring as many things to the table in making your representations as you can, and we've covered already human rights representations at large, and it's important not to see these things as well, maybe this or maybe that, but to think about, well, what can I bring under each limb? So if you think about what judicial review challenge might be, it might be at common law or under human rights provisions, or potentially even if we have enough data on the grounds of an Equality Act challenge to an individual decision. And just in that context, it's worth just noting actually that a claim, of course, a representation that a refusal is inconsistent with human rights, of course, allows you to bring effectively what is a claim under the Human Rights Act that the decision is incompatible with human rights, rather than simply a judicial review. And so into that pocket of things, just talking about human rights for a moment, all of the things which we looked at on that slide, on the first slide of representations in relation to the rights of the child under Article 8, and the need to interpret the Human Rights Convention compatibly with other international human rights treaties in relation to women and children and persons with disabilities, but also in relation to refugees and stateless persons. All of those things can expand over time the scope of Article 8 in constraining this sort of behaviour, because they take things off the table. And that's the developing jurisprudence there. And so when we come on to look at that as one attack, to look at maybe what's the scope of Article 8, what's the scope of Article 8 taken together with Article 14, where you argue that someone who's making a dangerous journey might be considered to have an other status for the purposes of discrimination on grounds of Article 14. You've got to see that alongside the different basis that you might have under the Equality Act. And the Equality Act is quite difficult and slippery, because you've got to ask yourself, what am I going to do about this? What is the basis for indirect discrimination as compared to whom? Because it may be that we don't have the data for this at the outset of this sort of journey into using the Equality Act to challenge individual decisions because there aren't enough individual decisions to make this something on which a proper inquiry can be made. But over time, we may find that there are differential impacts in the use of the good character test. And you can see it perhaps in relation, if you think about it in another context, just to make this real and put some flesh on it. If you think about the provisions made for criminal offences in the good character test, which say, well, if you've convicted of an offence for over a certain period of time, you won't be considered of good character. We all know that there is overcharging, over conviction rates and higher sentences for people from particular communities. And that's sort of imported wholesale into the good character test, whatever the outcome of that is, in terms of what criminal convictions you are and for how long. That differential impact in your journey through the criminal justice process is then reflected and refracted almost and expanded in the application of the good character test because it's simply without criticism brought into there, whatever criminal sentence you have. And so we may find that the use in a similar way, that there is a differential impact in the use of people, certain groups of people make journeys to the UK and are refused on a greater scale. And then there might well be some indirect discrimination there. There might well be a breach of the public sector equality duty. And I just wanted to touch very briefly on the way in which, because the Equality Act is not often used very much in relation to nationality, and there are restrictions in both in terms of the range of things which can be in an immigration decision can be made subject to, but a slightly different list of exclusions in respect of nationality. And it's just worth, because we're here, to think we might have this moment when we can bring alongside a human rights challenge or a common law rationality challenge or fairness challenge points about indirect discrimination, because there's no exclusion, as you see there on the slide, under Schedule 3 in respect of nationality claims as opposed to immigration under the Equality Act, from bringing a race discrimination claim on an indirect basis to include all the bases which normally fall within the race rubric under the Equality Act, so colour, nationality, and ethnic or national origin. And for those of you that familiar with the Equality Act, you'll know that only colour really survives in relation to immigration, but not so in relation to nationality decisions, where the full range of race discrimination sub-criteria are available. And then if we turn to the next slide, please, you'll see that, of course, we're at the outset of this journey in terms of gathering evidence to see whether there is prima facie a case of indirect race discrimination on particular facts and whether the Secretary of State seeks to justify it. But it's worth bearing in mind that if this policy is stuck to and the Home Office do start making refusals, then the evidence of differential treatment may become available depending on who they're refusing. And we may find that people from certain backgrounds tend to get refused more than others. And that's why we're putting down a flag or a marker at this stage to draw this to your attention. It does actually work rather confusingly. The difference in the Equality Act between the treatment of nationality refusals of registration or naturalization works differently as regards indirect discrimination than it does in respect of the public sector equality duty. And then we're only going to touch on this very briefly today because that public sector equality duty may often be best directed to a challenge to the policy and not to an individual decision. The use of this provision in respect of individual decisions across a range of subject areas outside of immigration and nationality is a little bit problematic from time to time. But you can see there that there it's protected or limited by the application of Schedule 18 of the Equality Act, which does exclude considerations for the purposes of the public sector equality duty of the subclasses of race discrimination, nationality, and ethnic or national origin, leaving colour as the sole basis on which you can bring a challenge for breach of the public sector equality duty by reference to race. So you have to use colour as a proxy for the other factors if you're going to get home on that. And that's different to indirect discrimination, where all of the subclasses are available under the race discrimination rubric. And then if we can turn to the next slide, please, Anisha. I think this is one now where I'm going to hand over to Ava, who's going to take you through some of the practicalities in terms of what we need to be thinking about.
Thanks very much, Adrian and Sonali. So my role really, we have 15 minutes left, is to give you a bit of a recap, firstly, of what we've discussed, and then talk a little bit more about the practicalities. So we had a very helpful list of common questions. And really, I went through them and made sure that we covered everything off that seemed to be concerning the sector in particular. So really, the first slide, Adrian and Sonali have already covered it beautifully, but I'll just recap what the good character requirement is and why we're concerned about it. So obviously, the good character requirement, you all know, applies to most citizenship applications, and Adrian has set them out in full in the beginning. Then the recap, there's no legal provision that defines good character, which is really helpful. So we have no statute defining it, but the Secretary of State sets out her views in her policy guidance. So it's really important that when you write representations, you always have to refer to that guidance and yeah, make it relevant to that. So issues affecting the good character requirement or a person's good character include both past criminality and then also breaches of immigration laws. So really what's important, Sonali talked you through the criminality issues that may arise where people make dangerous journeys. So if your client has a criminal conviction for making a dangerous journey, it will be far more difficult to for them to achieve or get British nationality. But now also making dangerous journeys is also or also impacts a person's good character because of the breaches of immigration laws being considered adverse to a person's good character. So the crucial guidance amendment on the 10th of February was this requirement that I set out at the bottom of the slide. So any person applying for citizenship from the 10th of February who previously entered the UK illegally will normally be refused, regardless of the time that has passed since the illegal entry took place. So again, next slide, please, Anusha. This is very much recap of what's been said, but these were also some of my preliminary thoughts on this bit of the guidance. So the good character requirement applies to anyone who's over 10 years old, so including to children. And then there's this really interesting bit of the guidance that's always been there, that there's a discretion to disregard immigration breaches that occurred when an applicant was a child, if it's accepted this was outside of their control. And Sonali spoke about this briefly earlier, where she cited this very interesting answer to a question from Baroness Lister. And I find it really interesting because my first take on this was in what circumstances may illegal entry be outside a child's control. I think it'll be really, really interesting how this is going to be applied. And I'm not so certain that the position that's going to be taken that a child has not normally, or there's some kind of presumption that a child has not normally, or is not normally to be considered to have illegally entered. We'll see what happens, but if you make representations on behalf of people who have illegally entered when they were a child, it's really, really important that you cite the answer to this question by Baroness Lister in your representations. Now, the point on normally there's a discretion, or really what we discussed and what Sonali and Adrian have been emphasizing is not really a discretion. So this is the good character requirement is one of the unwaivable requirements for citizenship. So what I really should say in this slide is that there's an evaluative assessment to be done by the Secretary of State, and that is where we have a hook for legal challenges, really. It's still to be seen how the Secretary of State is going to exercise that discretion, or how she's going to decide to evaluate facts in individual cases. But the point is, and I just included it here because one of the questions was, should our advice be to prospective applicants that they just are excluded and shouldn't make applications? And the answer to that question is no. There is scope for argument, and depending on your facts, you may well have very good merits on, your case that your client is actually not or should not be seen to be falling foul of the good character requirement. So this is not a blanket exclusion, if you like, but it's worth, litigating if you've got, especially if you've got good facts for your client. Now, yeah, another thing that at the bottom of my slide, really what I found interesting is that obviously this applies, the requirement applies retrospectively and regardless of when the illegal entry occurred. And that's really interesting because it's kind of at odds with the general understanding that any non-criminal matters that happened over 10 years ago are disregarded for the purpose of the good character requirement. This is clearly not the case in relation to that requirement, but I think it's still kind of useful to set this out in any representations, especially where it's a long time ago. Okay, my last slide. Now, this is more about the practicalities of making applications and also, very importantly, the remedies. Now, the cost of a naturalization application for adults is currently £1,630. And again, this came from one of the questions, but that is not going to be refunded if the application is refused. And unfortunately, there are also no fee waivers available currently for adults. Now, the remedies, and that is why it's also really important, and that comes out of the remedies as well, that when a person makes the initial application, you have to make sure that it's the perfect application, yeah, that you say everything that could possibly be said and raise the right factual and legal points at that stage, because you don't want to have to reapply because it's very expensive. Now, remedies against refusal is one, a reconsideration request that also attracts a fee of £450, but you can ask the Secretary of State to reconsider her decision. Now, it's really useful, and I'd urge you to look online for that. The Home Office has also a published reconsideration request guidance that is specific to citizenship applications. So do have a look at that, which is really useful. But in that reconsideration request, you'll want to, again, put forward your best points and really the arguments that you'll want to be running in any future application for judicial review. So really, it's good in any event to prepare any of these applications where you have concerns about the good character requirement from the outset, as if you were ultimately going to litigate this in court, especially because we don't yet know how this new guidance is going to be applied. And then after, or if you failed in your reconsideration request, you can then apply for judicial review. Obviously, the first stage is to go through the pre-action protocol correspondence, which is helpful because that will give you another opportunity to succeed with your arguments before you're actually going ahead with an application for judicial review. And the grounds, I mean, Sonali and Adrian have talked you through them in detail, but they're really relate to questions on the interpretation and application of the law. So lots, for example, what Sonali spoke about, the what legally is a dangerous journey. Yeah, there'll be a lot to be said about that, and whether potentially refusal on this basis would amount to a breach of Article 31 of the Refugee Convention, slightly depending on what happens with the policy challenge in relation to that. Then it's also important that obviously this is judicial review, so your judge is not going to be a primary decision maker, but what they do is they review the decision of the Secretary of State. So rationality of the decision is going to be very important, fairness, but then also fundamental rights compatibility. And that's where also Article 14, discrimination arguments, the Equality Act, may come into it. And then just to reiterate this point on children, Yeah, if your applicant or your client was a child when they made the dangerous journey, there are good arguments that not accepting this or not disregarding that for the purpose of the good character requirement may be a breach of their own guidance, or you could try and argue that. And then there'll be arguments around what is outside of a child's control. Yeah. So it's going to be interesting. And we'll see how it develops. Hopefully, we'll have more seminars like this in future where we can actually give you more kind of guidance on how the courts are going to interpret this and how they're going to deal with these kinds of challenges.
Thanks.
I'll hand it back to you.
Thanks so much, Ava. We've generated a lot of questions. So I wonder if we could stop the screen share. And we can go through some of those questions. I think there are 16. We'll just try and get through as many as we can. I think one of the overarching things is that there's a policy challenge afoot, that might lead to some amendments to the policy, and I would hope it does, to reflect some of the considerations that we have discussed. But unless the policy is withdrawn as a whole, what you have seen is seemingly either intentional or in any event an attempt, a discouragement of citizenship. Previous governments have had an encouragement of citizenship that we saw in Firma Fairer Faster. Let's encourage citizenship. Let's, to build a cohesive society of citizens. And that's something that is definitely a consequence of this policy. If swathes of people are going to be, or purportedly, excluded by the criteria set out there. So we just quickly, perhaps what I'll do is I'll just go through the questions, and Adrian or Eva, please do address some of these if I can. I think we talked about, first question was kind of about covering the paragraph on illegal entry as well, which is, I think Ava did cover that, which is, I'm not clear how the dangerous journey criteria adds to the first paragraph of the other section. And I can see the confusion, because what it says, the first paragraph, as Ava put on her slide, was any person applying for citizenship from the 10th of February who previously entered the UK illegally will normally be refused regardless of the time that's passed since the illegal entry took place. So they've made that bold statement under illegal entry, and then there's the next section is the part about dangerous journeys or arriving without a visa. So, well, if you've arrived illegally, perhaps they're trying to go back to the criminal framework of illegal arrival and illegal entry. I don't know if that's what you thought, Adrian.
I think they're fitting the two together. So they've changed illegal entry so that it dovetails, of course, because if you arrive, you don't enter the UK. If you're detained in territorial waters before you've entered the UK, obviously Section 11 of the 71 Act applies, and you wouldn't fall necessarily within the definition of illegal entrant in Section 33 at the back end of the 71 Act. So I think what they've done is that they've adjusted. So arrival being different from entry, in introducing the dangerous journeys provision, which applies to the crimes of arrival, they've also in line adjusted the illegal entry policy for those applying from the 10th of February. So it's not a good news answer, but it is an answer as to the alignment of the two. They are different for the purposes of the criminal law, and so I think they're also different in the good character test, and so that's what's going on there.
Yes, and another question there on illegal entry, which was, if an applicant arrived in the UK illegally, irrespective of whether they've made a dangerous journey, but then left voluntarily to apply for entry clearance, which was then granted, and then they acquired their leave, would they still be caught by the illegal entry provisions? I.e., do you have to be in the UK on the basis of illegal entry for these provisions to be applicable? I mean, my reading of it could be used, but that's not the primary intention of the policy, but it doesn't exclude that. I don't know if that's how you read it, Adrian or
Yeah,
Ava.
no, I did too, actually. I think it could be used exactly. It could be sort of pluperfect, had arrived, rather, but it says has arrived previously, but question of how far far back you go. In a vindictive way, it could be used for those people that have arrived, left, and then come back again. So, but it might be subject. I mean, that's exactly the sort of vintage scenario where, of course, it matters that it's good character as at the date of decision. So we were sort of saying, yes, of course, in principle, you could apply it, but the will normally factor then comes in. Why not on this occasion? Well, because it's ancient, and it's about good character now. And so that's why we should always remember the holistic situation. I think it has
Yes, and if you've subsequently been granted leave, but that's not a complete answer. Another question about the illegal entry. Presumably, illegal entry will only be illegal if considered so at the time, i.e., if before NABA a person was brought in, it wasn't in a way that wasn't illegal before NABA. But not sure that I think that is right, and technically, but I can't think of what. Given that you're looking at illegal entry under the 71 Act, I'm not sure how that would bite.
I mean, I think the guidance has always never really tracked the definition of illegal entry exactly. It's always been for good character purposes. So it's true that, of course, if you are within the scope of the 71 Act definition, it's likely to apply, but they've always taken it's at the date of decision. That's the problem. It has, and it doesn't require a criminal conviction for illegal entry. And
Yeah.
it's more whether it's within the scope of the provision. So it's not. That's the dangerous part of it, I think.
There's another question, so I'm just going to try and bunch all the illegal entry questions together and then come back to some of the others. But another question is, if an applicant has arrived in the UK illegally, what's the if they would normally be refused citizenship, what's the purpose of the further category of the dangerous journey? But I think we've dealt with that now, haven't we? Because we decided it was a distinction between the different criminal context of illegal entry and illegal arrival. So another question, which is, if a client enters with valid leave to remain but overstays, will this now impact their nationality application? I.e., does the good character requirement remain at 10 years with valid leave? And the overstaying provision is there in the policy on its face. And it says where you're not disregarding immigration breaches relating to lawful residents. If a person's previously overstayed, overstay permission to enter or stay will normally be appropriate to refuse the application for citizenship unless it's the sole adverse factor weighing against their good character, and either the application was made on or after the 24th of November 2016 and the application didn't fall for refusal on grounds of overstaying because of the exception under paragraph 39E, the disregard of the immigration rules, or the period of leave without leave was not the fault of the applicant. For example, where it arose where a Home Office decision was withdrawn and then there was a reconsideration. So I don't know if that answers your question. Don't know, Adrian, you've had anything else to answer?
I mean, just that obviously it's separate from the consideration. I mean, they've aligned illegal entry and illegal arrival because it addresses the common concern. With overstaying, it's not about you having recently arrived on an improper basis in any format. So I think it doesn't seem to have a 10-year yardstick on it anymore. I noticed that, but it's sort of self-contained. I mean, there's just two carve-outs of other when it will not normally be refused. But again, it's the overarching decision that matters, the holistic position at the date of decision. So there's always scope. There's more scope for overstaying reps, I think, than for illegal entry or illegal arrival reps.
Yes. Gosh, we have so many questions. I'm gonna try, because we did advertise ourselves to go a bit further till 6:30. I think we can see if we can try and get through them. One of the questions was, is your reading of the response to Baroness Lister that it would apply to young people who arrived as children but are now adults? And yes, I agree. I think that's how I read it.
Or
Another,
that's
yes,
at least how it can be read. So
yeah.
I think we should read it in this way. Should I also briefly there's one very long comment on costs.
Oh yes.
I'm sorry, I have typed some answers as well to try and
Yeah, no, that's fine.
hear
Absolutely.
some of the answers. But I think that there was a point about in addition to the application fee, we've already said it's really important that people are represented, because really this is going to require quite a lot of complex representations and evidence, is this going to be feasible for people to even pay the fees? And I think that's a very valid concern. Without legal aid, this is going to be really, really difficult, and has always been a huge challenge for people. And it's obviously far more challenging when you don't even know if your application is going to be granted or not. So yeah, I agree that it's a huge problem. Do you know, Adrian or Sonali, are there any particular places, advice, charities, other organizations that may provide free legal advice or representation? Outside of the children context, I'm not sure. I think it'll be difficult.
No, it's probably ripe for development in terms
I
of.
think that's probably why we are getting so many queries. And I did a session yesterday for the Migrants' Rights Network, just giving some general sort of statements again. And I think that is a matter of real concern. I know because if ultimately you may be able to get exceptional case funding to bring a judicial review, but you won't even get to that point until you know you've had decent advice to make the application in the first place and make the representations and then get the decision. So all of those are of particular concern. Yes, I think the scope of legal aid would only come within a challenge on and still exceptional case funding, as I understand it. Although I'm happy to be corrected on that. There's a question there just on statelessness for Adrian. She said, I know it's niche. Could you point out that Section 9 definitely includes stateless persons and not nationals as well as nationals?
Yeah, Section 9 of the Equality Act. No, absolutely it does. And thank you for the additional sort of footnote to that. It's worth bearing in mind that they are also protected by the Equality Act as we know. So
okay, that's very useful. Thank you, Judith. Another question, which is back to this point about the illegal entry. There's a section, a part on page 50 of the guidance under the illegal entry section, which states that those who arrived illegally without reference to dangerous journeys will normally be refused. What's the significance of the dangerous journeys section, specifically excluding commercial airline passengers in the guidance for those who arrive by air with entry clearance but are later deemed to have entered illegally by verbal deception, i.e. those who arriving as a visitor who later claim, as the Secretary of State argues, never intended to leave? Well, that's an interesting question.
I suppose it's possible. Obviously, deception is covered by entry, but I suppose if you hijacked the plane and brought it to the UK, that would be a dangerous journey. It wouldn't be deception. I mean, you can see, I think this sort of belt and braces, isn't it? That they're trying to say that if you come here and you claim at port, you're not on a commercial airline, you're not caught by the dangerous journey provision. You're not caught by the illegal entry provisions.
Yes, and it's not an illegal arrival.
Exactly. Yeah.
But I think that's back to I think that argument is about the entry versus arrival context. I think that's the way I read it anyway. Just one of the issues was in relation, but I think this is back to children or outside of a person's control. Can we argue that this was in the case of someone who's severely disabled coming with a relative? Again, I think those are fact specific. You'll have you will have a scenario if on your evidence, if your evidence is that that your arrival or entry was outside of your control because you were brought here, and whatever those facts are, either as an adult or as a child, then those are fact specific and certainly capable of engaging that that provision. There was another question which was about please address the fact of when someone enters illegally, goes back voluntarily to enter with an appropriate visa. I think we've dealt with that again, which is it could be used, although that doesn't appear to be the basis upon which the main target of the policy is, I suppose, is the way I've put it. And there was another question. This is one that came up yesterday as well. Is it the case that a refugee's dependents who've come via family reunion could go all the way to citizenship, but their spouse may not? And I think that is potentially the logic of what could happen if a refugee gets their refugee family reunion, but the refugee themselves entered illegally, unless you succeed in your Article 31 argument. And I think that exposes some of the problems and potential incompatibilities with the Refugee Convention and other aspects of human rights law. Adrian.
Yeah, I mean, I agree with all of that. I just wanted to add that obviously things like Article 34 about the Refugee Convention in terms of the assimilation and naturalization of refugees, we always have a problem with it because it's essentially an unincorporated aspect of a treaty. But that's just to reinforce that if you're trying to develop what constitutes a compatible decision for Article 8 ECHR purposes, and in terms of a person's life and their private life, interpreting it compatibly with the provisions that are available to protect them in other international human rights instruments is not an illegitimate thing. And although no court has gone that far so far in respect of Article 34 and its relationship to Article 8, it's worth bearing in mind that this is a developing area, as Sonali said earlier, in respect of Article 8 and citizenship, and that we need to think a bit more creatively about how we try and say these things buttress what is available to us domestically in terms of fundamental rights in Article 8.
I've just had 3 comments, which I think are really important from very eminent and experienced solicitors who do say that ECF is potentially available to make applications. And I think that's a very important practical thing that solicitors know much more about than barristers. So I'm very pleased to see those comments. Thank you for. Can those with a humanitarian protection have specific arguments in line with those with refugee status, particularly in cases where they didn't decide to do a sort of top-up appeal in the past? Will that come back to haunt you? Adrian, do you want to take that while I'm just
Yeah, no, sure. Yes, because it's about being forcibly displaced and about being at risk of harm. It's different to the Refugee Convention, obviously, and obviously it's not underpinned by the Qualification Directive anymore, but it's a sort of domestic provision. But it's a sort of common law point, isn't it, about what you've been compelled to do and the recognition of that and how it's recognized in the sort of complementary protection status that you've got. So it's not exactly the same, but there is force behind the idea of saying this is why you should not apply it in this case as well. And it might be an interesting example of how the common law progresses in parallel with international human rights treaty provisions to give sort of to like effect and might actually help extend the protection under that sort of approach rather than just under the ECHR.
Yes, there's just a link in the questions, which I think Eva, you might have posted that, which is an opinion piece for the BMJ, denying refugees British citizenship as a shameful backward step. That's a piece that Kolbasia from Freedom from Torture has written along with Angela. Thank you very much for circulating that. And I hope people have a chance to have a look at it. Another question or observation was if there's a possible argument of common law unfairness or even historical injustice on the basis of the change of policy concerning arrival and using the dangerous journeys in particular being applied retrospectively, and that a potential applicant couldn't have done anything to improve their historical method of arrival in the absence of any indication by the Secretary of State in advance of the application of the new policy. I think that's one too that may end up being litigated, but I think my instinctive response is ordinarily a Secretary of State can change her policy, or any government department can change their policy. But the question really for me is about whether there's a compatibility point there with the Refugee Convention and other human rights instruments. But I'm not saying I'm ruling it out. I'm just observing that it's not ordinarily it's ordinarily quite a difficult position. Some practical questions about putting in supporting letters. I think if you're going to put in a supporting letter about good character, the person who's writing it needs to be really clear about the person's character and what might be said against them. That's just a really practical example of someone saying, yes, I know this person, they're of good character. But did you know that they entered illegally or or had an illegal arrival or entered on a small boat? If you did, and they're saying, I still think they're of good character because that's, fine. But I think it's really important not to sort of overstate or understate what the relevant issues are. Now, another question, do you read the first paragraph on page 51, which is where you're not disregarding immigration breaches relating to lawful residents? If a person has previously entered the UK, it will normally be appropriate to refuse the application if illegal entry is confirmed as having occurred in the preceding 10 years. Do I read that to only refer to applications made before the 10th of February? Oh, that's an interesting question. Yes, I think that is, if you read it in context, it does look like it is in relation to the 10th applications before the 10th of February, if you look at where it logically seems to follow in the document. But I'm not sort of going to necessarily hold myself to that. I mean, we need to be careful about, we're trying to give people information. We can't give it really clear, can't obviously give any legal advice to any individual clients, but we're just trying to raise legal arguments that might be put, encourage people to seek legal advice, and to to make representations as appropriate. If an unaccompanied asylum seeking child brought here by agents or traffickers granted asylum, are they likely to be refused now in light of the latest guidance? Yes, we have really dealt with that on the answer, I think, hopefully is in the slides and in the reference to the trafficking provisions, and in answer to Baroness Lister's point, clarification in the PQ. What would happen if a person arrived in the UK on a different visa, later claimed asylum? Would this affect good character? I mean if you're entering with deception, then that is going to be a question about good character. And if you claim asylum and are granted asylum, then the question will still come back to your Article 31 as to whether you're being penalised for method of entry. So I think that's the same sort of point that we've dealt with before. Sorry, there's one about people who are on small boats under duress, and I think that is, I mean, that is certainly the experience I've understood from certain clients that I've encountered. So I think that, if those are your instructions, I mean, obviously you have to be, it's still a question of the Secretary of State has to be satisfied. But if you put your instructions, those are your instructions. Difficult to evidence apart from via your own clients' evidence. But again, there is objective evidence to support in some of the NGO reports around small boat crossings about how people are acting under duress in not only sort of being forced to steer boats, but also including forced to board them. So any other, if there's any other questions, I think with the Article 31 provision not to penalise individuals for entry, assist with humanitarian protection. And I think that's, I mean, that is a difficult direct point in the sense that we've got the Refugee Convention for refugees, and that is necessarily, the Refugee Convention does have a sort of hierarchy of rights. That is the nature of the Refugee Convention. One could, depending, I think that could be a fact-specific argument, not about Article 31 itself, but one could say that it was not reasonable to penalise somebody by method of entry if that arose on the facts. But I can't. It's difficult to argue, but it's certainly not an application of Article 31 as a direct reliance. So that's the first point. I think we have probably exhausted our time and our questions. And I'm particularly thankful for that article from the BMJ, Dr. Burnett and Kolbasa Hosu. So thank you. And I just think that the reality here is that we're going to have a lot of questions. People are going to need significant amounts of advice. And the question of where that happens is going to be a problematic one for a lot of people if they can't access legal aids. I'm very grateful for that comment from the solicitors who were online to say that it certainly may be possible to access ECF, and it may be that that's another part of a sort of collateral challenge, if you like, if people aren't getting ECF but need it. And we've seen that in the past with certain types of work being ordinarily out of scope. But that was in a circumstance where there weren't very many challenges to be brought. And then if suddenly the policy changes, then it may well be that those criteria under ECF might have to be looked at again, or indeed potentially another challenge brought there. We need to see how far the policy survives the extant challenge, as I understand it is, from but it's being brought by Duncan Lewis solicitors, and I've only seen an outline of that, but includes Refugee Convention and ECHR grounds, according to what I've read. And the only observation I would leave was in response to the challenge. In response to the change of policy, the House of Lords Minister Lord Hanson said, well, we've strengthened measures to ensure that anyone who entered the UK legally faces having British citizenship refused. We take our international obligations very seriously, and the good character policy is compliant with those obligations. Well, that's what the government have said. That's not what on its face, we've given advice, or we're not given advice, or we've given our view on what we say in terms of the potential challenges. And we'll have to see what happens next. As Eva said, that there's going to be a lot of developments on this front. But I think it's important, I think, Adrian, you mentioned this when we were talking about it earlier, that what's going to happen to a group of people who are here in the UK with indefinite leave, maybe for a long time, if they're excluded from naturalization, they're not going anywhere. They're settled persons here, but not being integrated into the UK. Is that really what is intended by this policy? And that to me is an unhappy state of affairs, because this is long post cessation. We're not doing, you've gone from refugee status, you've got to indefinite leave. So as a policy decision, it does seem an unsatisfactory one in terms of integration, Article 8, and what to do with, in particular, refugee populations. So anyway, thank you very much for coming, and we did stay on to the end of the time so we could try and answer some of the questions. Obviously, if anyone needs particular advice, then obviously that's a different matter to go to see how that can be facilitated. But today we were just giving our views on where we see the land lying. So thank you so much for coming, and thank you to Adrian and to Eva for giving your time and assistance here. And we'll leave it to a close. Thank you.
Thanks very much. Thank you. Thanks to Sonali as well, of course, for leading on it.